Commercial Disputes Resolution in Vietnam, part of the series Global Business Law in 20 Minutes with Federico Vasoli. This is our topic for today.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hi, everyone. This is Mac Pierre-Louis, attorney, mediator, and arbitrator, working throughout Florida and Texas.
And I am Natalia Łowska-Czajka, advocate, mediator, and arbitrator in Warsaw, Poland.
And I'm Federico Vasoli, Italian lawyer, managing partner of the MTV Global with offices in Singapore, Malta, and Vietnam.
All right, good to see everyone again. So in the last two episodes, we covered Vietnam as an investment destination. Inevitably, businesses face commercial disputes over time, and the same applies to those that do businesses in Vietnam from abroad. So, Federico, please start us off. What typically gives rise to commercial disputes in Vietnam?
A lot of things. One problem is, of course, distance. So you mentioned companies that have invested directly in Vietnam, so they're technically Vietnamese companies, even though the shareholders are foreigners. Or part of the shareholders are foreigners, and businesses trading with Vietnam from abroad. In the second instance, distance definitely plays a role, especially with the pandemic, when traveling faces so many restrictions. It is really difficult to check quality and quantities of goods on both sides. So it happened to me so many times to receive questions, emails, calls from companies, from non-Vietnamese companies that had sold something to Vietnam and they didn't get their money, or the other way around. Some foreign traders that bought something from Vietnam and they never received the goods after, or services, but typically the goods after paying the agreed price. Now, I don't want to say that the other way around doesn't work. Actually, the other way around happens all the time as well. So you do have Vietnamese that don't receive their monies, they receive faulty goods, etc. So distance definitely plays a role because you don't have the possibility of checking the actual goods. You cannot inspect them properly. Yes, you can rely on agencies. There are famous, prestigious agencies that do that. But being there locally makes a hell of a difference. So that is one problem. Another problem is, of course, the language, because Vietnamese is a difficult language. It is the only official language of Vietnam. So even though English is indeed spoken and many other languages are relatively common to be used in business in Vietnam, translations may not necessarily be accurate. And then the standard contracts are, allow me to say, not properly well drafted. So we kind of repeat what we said in the first episodes of the most common contractual mistakes, but having a proper legal agreement, that is written and enforceable, saves you. It really does. Also, when it comes to dispute resolution, because you may want to include an alternative dispute resolution forum, you may want to apply a foreign law, foreign jurisdiction different from that of Vietnam. And these things have to be agreed upon in writing before problems arise. So typically I would say distance for those that are not physically there, language for both, not having proper agreements in place for both, whether you are in Vietnam or you're far away. And I would say also legal complications, in that the law in Vietnam could be quite intricate, as anywhere in the world. I mean, imagine the Security and Exchange Commission in the US or antitrust regulations in the EU and so much more. So regulations are complicated all over the world. In Vietnam, they are particularly thorny and sometimes even contradictory, like anywhere else of the world. So in the world, so even that could pose a problem.
And having said that, and back to our previous episodes, we also covered jurisdictional issues and applicable law as part of the contracts and contractual mistakes which can be unfortunately made in the contracts. What can you say about that in Vietnam? How important it is to have a jurisdiction clause and how important it is to have a clause regarding the applicable law, and to which extent maybe it can be introduced?
It's fundamental. Like anywhere else in the world, it is fundamental because if you don't put it in a legally binding and valid and enforceable clause, then somebody else will choose for you. Somebody else could be the law. The law could have its definitions. So that type of legal relationship is governed by, let's say, Vietnamese law. It could be another jurisdiction, and will end up in court in Vietnam. And sometimes you may not want to, you may or may not want that to happen, but for sure you want to choose. You have the possibility to choose. Why don't you choose before things go sour? And let me add something. I mentioned standard contracts before because I've seen in practice so many of these very simple. They look like forms, really. I didn't. It just come up to my mind now. I should have shared my screen here, but you see these forms that say, I don't know, names of the parties, goods to be traded, unit price. That's it. That's it. Are you kidding me? This is what. But I've seen it really for millions of dollars or euros. I'm not joking. There have been so many cases of these companies, these contractual parties, whether Vietnamese or foreigners, that faced massive problems due to very poorly drafted agreements. Maybe these agreements are drafted in two languages. They are translated. They are in both Vietnamese and a foreign language. Typically, if you've ever seen something like that from Vietnam, typically you have the Vietnamese version typed normally, and then just under it you have the italic version, which is the translated language. So typically you have Vietnamese and English, Vietnamese and French, Vietnamese and whatever. Vietnamese, and in italic the foreign language, the foreign translation. There's not even a clause that specifies what happens in case of discrepancy between the two versions. So, and it's so difficult to read because they're drafted in a visually difficult way, for me at least. I'm used to much neater editing of agreements. So these agreements do not go anywhere. They don't go far. They don't protect the parties. And eventually what you can do is you try and go to court in Vietnam or abroad, and then you try and enforce the favorable sentence, if any, in Vietnam or abroad. Difficult, very difficult.
Now, Federico, I know because of time, you're not going to be able to give a really in-depth answer to this, but typically, how are disputes resolved in Vietnam?
3 ways. Number one, you have a good agreement in place that specifies where you want to go to court, where you want to settle your disputes. And it could easily be that for arbitrable matters, you opt for arbitration. Arbitration could be conducted in Vietnam or abroad. Good news, Vietnam is part of the New York Convention on the Recognition of Foreign Arbitral Awards. So if you go to arbitration in any country that is part of the same convention, typically Singapore for geographical reasons, and because Singapore is sort of the gold standard in the region, but it could really be anywhere in the world that is part of the New York Convention, that's fine. Number two, you go to court in Vietnam. You go to the People's Court, which is a lengthy and difficult thing to do. I'm not saying I'm against it per se, but it has to be a conscious choice. And evidently, if you go to court in Vietnam, everything has to be conducted in Vietnamese. You have to have a locally qualified lawyer that represents you. You have to trust this lawyer or this team of lawyers. It may be the only solution you have, especially for matters that cannot be settled otherwise, but it's my second choice. The third choice, which also applies to commercial disputes, is to see whether the matter includes some nuances of criminal law. So, can a missed payment be interpreted as embezzlement or fraud or even theft? Now, difficult. It always depends on the elements, and let me reiterate that we're not giving any legal advice in this video. But it could well be that there are some elements, some subjective elements, that in a way support a criminal case. If that is correct, if that assumption is correct, then going to the police could be, in Vietnam, not abroad, could be a good solution. Why do I say not abroad? Because contrary to what happens with arbitral awards, there are a few countries with which Vietnam has criminal procedural law agreements with. There are agreements in place with the US and other countries to combat terrorism, money laundering, etc., or particularly violent crimes or organized crime. But simple theft, embezzlement, etc., no, that's not really covered. So if you go to the police in Poland, in the US, anywhere else, it is difficult to have that report sent all the way to Vietnam and have it enforced there. Also because the police in Poland, in America, will conduct their own investigations, and they won't necessarily share them with the Vietnamese police. But these are the three ways, typically.
And how easy or difficult for a foreigner, a foreign entity, it is to go to the court and pursue the claim in Vietnam?
Okay, it's on paper quite simple. That is, if you have a legitimate interest or a right to defend, you go to court and you start legal proceedings. The difficulty, again, lies in procedural aspects that are made complicated by the fact that everything is in Vietnamese, of course, that's only logical, but also the paperwork necessary to prepare the dossier for the court. I'll give you an example. We assisted a while ago a big name in architecture that had to sue a Vietnamese company that did not pay the agreed amount based on a really badly drafted agreement. We didn't draft it ourselves. But anyway, we needed to go to court. There was no jurisdiction clause, and so we had to go to the People's Court in Ho Chi Minh City. Now, all the documentation had to be translated into Vietnamese, of course. It had to be legalized by either the Vietnamese embassy, in this case in Italy because the architect's firm was Italian, or by the Consulate General of Italy in Ho Chi Minh City, and then submitted to the court. There was a problem here. That is, I might have mentioned this case before, that the company, the architects that we defended, were incorporated many years ago in Italy under a certain name. Then, in the course of their life, of their business life, they changed name. Not once, but twice. So the judge saw the certificate of incorporation of our client that was initially established as, let's say, number one. Then they saw the contract that, as bad as it was signed as company number two. And then the party that started that instated legal proceedings was company number three. The judge didn't understand anything, so we had to explain to the judge what had happened, and it was a difficult exercise. We needed to actually have a note drafted by the Consulate General of Italy in Ho Chi Minh City that explained the situation to the Department of Foreign Affairs of the city, that in turn transmitted this note to the court. And long story short, it didn't end well. So yeah, easy, let me breathe. But it's in practice, it can be very complicated because the Vietnamese, like many other Asians, generally speaking, this is a broad generalization, tend to be extremely precise. So like in the example that I made, if they see that a company was incorporated as company A and then it instates legal proceedings as company B, they already question that. What happened? Please explain to me what happened in the course of the life of this company. So that is it.
Thank you for that. Thank you for that. That was an interesting example, and I can only imagine on top of all of that, there's a language this component as well, right? That would have
Yes.
tricked things up.
Yes.
Okay,
Yes.
so now we're moving on to something that's very dear to Natalia and my heart, and that is mediation and arbitration, generally speaking. So, can you tell us, in the big scheme of all of this, once people find themselves in dispute and in conflict over their business transactions and relationships, how does mediation and arbitration factor in based on your experience in Vietnam?
Mediation is culturally very much accepted and welcome. That is, if you can, Vietnam is not a country where you have so much litigation as in the West, typically in the US. Notoriously, the US is a country with a lot of litigation cases.
We sue for everything.
Okay. Vietnam is not. Also because of the way culture works, because of Confucian values, because of the tendency to try and find a solution before shooting at each other, let's put it this way, in legal terms. So mediation is highly accepted. It is actually not so much regulated, but there are a few mediation centers. They're springing up. So it is worth monitoring them and their activity. I'm afraid I'm not that much of an expert, but I do work with mediators in Vietnam. And according to their experience, they did find solutions for commercial disputes. Arbitration is more senior, let's put it this way, in Vietnam. That is, mediation is relatively new. That is, mediation exists, is ingrained culturally in Vietnam, but is not as formalized as it can be in other jurisdictions. Arbitration is something that has been set up virtually at the beginning of the opening up of Vietnam as a business destination. So first, as I mentioned, Vietnam is a party to the New York Convention on the recognition of foreign arbitral awards. And then there are indeed local arbitration centers. There are many, even with foreign arbitrators, that could be particularly useful. Well, of course, when there is a foreign party involved, and also when the industry in which the parties work is specialized. So the other issue that we face in Vietnam is that judges are not necessarily versed in, let's say, technical industries. So they may not fully understand the technical sides of the case, not the legalities. Of course, they're trained to understand the legalities, but the technical sides, not so much. Arbitration centers sometimes have experts that are specialized in specific industries and can lead the way in that direction. One solution that we opted for several times is actually to split the arbitration clause in two. That is, this is a subjective definition, but let's say that a company sets a limit to what is expensive, to what is valuable, gives a number in US dollars, in Vietnam dong, in whatever other currency. And in its contracts, it states that disputes whose value is below this threshold arising from or in connection with this contract will be submitted to adjudication to a Vietnamese arbitration center. Beyond this threshold, because it is for them, subjectively, an important amount of money, a significant amount of money, then the arbitration would be conducted somewhere else in a more prestigious, in a more even expensive and specialized arbitration center. Typically, it's Singapore. So if it's a petty case, they go to Vietnam. If it is a complicated one that requires arbitrators that have to pass exams, they have to have certain qualifications, etc., they go to Singapore or elsewhere. This is typically this is a solution that we envisage for certain clients that didn't want to go all the way to Singapore or to other expensive arbitration centers. and thought that this could be a good compromise.
Having said that, we've just met our goal, or actually our limit of 20 minutes, as we want to do the global business law in 20 minutes with you, Federico. This is a topic that I understand we can expand on in many different ways, and I hope to hear so much more from you on that in the future. But bye for now, closing, and thank you for all the insights, Federico. See you soon, next time.
See you next time. Thank you.
Bye, everyone. See you later.